Hi everyone, welcome back to my channel. In today's video, I'm going to talk about mistakes most advocates make when it comes to charging clients. As you all know, when starting out as an advocate, charging clients is normally one of the difficult things a lot of advocates encounter. So I'm going to share the mistakes based on my own experience. Mistake number one, failing to bring up the legal fees as the first thing. Mostly when we're starting out, you feel you still have that, the confidence is not yet well built up. So you're scared of charging clients as the first thing because because especially you're in that stage where you don't want this client to go away, you don't want to chase these clients. So there are mistakes that most advocates we normally make is we don't bring up fees as the first thing. So you find someone, when you get the client tells you what they want, then they explain to you what they want. Then for you now, you go ahead now to, even for instance, if it's filing an application under certificate of urgency, you don't first tell them how much you're going to charge them. You first go file the application. Then now after you feel like you focus first on the results. So after when you have gotten the orders is when now you inform this client that now these are the orders and these are my fees. That's normally the biggest mistake. Because let me tell you, at this point, first, you have already lost your bargaining power. When a client is coming to you, of course, they'll pay for the service you're supposed to render to them. But now you've already rendered the service. So your bargaining power is done. And trust me, this client, even if they decide not to pay you, there's nothing you can do about it. And most of these clients, as I always say, they wakwangi wajinga. They normally know what they are doing. So that's why when you find their clients they intentionally look for young advocates. So just always ensure you bring up the legal fees from the beginning. And at least you have gotten a deposit before. I normally say, like, based on experience, what I've learned, I never do any work before I've been paid. I don't render any services until I'm paid. At least, well, of course, you also become reasonable. Of course, you don't tell them if maybe you have charged, let's say, 150,000, 100,000. You can give them the option of paying in installments, but at least have a deposit first before you do any work. I know of a friend of mine, when he had just started his law firm, he was telling me the way he got these first clients. He was so excited. I think they wanted something in regards to drafting a lease and following up something. He did the work, like, kujitolea, like giving your all, because the excitement, and also you want to, because there's also, I think the idea behind this is normally when I do my work well, these people will pay me well. I don't know, but ensure you always ask for your fees as the first thing before you do any work. Ensure you at least have a deposit, because even I remember there's an advocate who was asking, at what point do you ask for fees? It's at this point that you ask from the beginning. The other second mistake most advocates will make is failing to get all the information before charging our fees. You don't get all the information from the clients. Then now, by the time, because it's normally hard after you've already told the client, for me to render this service, I'll charge, let's say, even 80,000. Then later you come to realize there are more. Because, for instance, if it's an application, if it's maybe like where you first need to do an application to get an injunction, or to get first some before you proceed to the main suit. Remember, this case now, this means you have, like, there's more to it. So you cannot, if I come to you and I tell you there's someone encroaching into me, as a client, I come to you and I tell you someone is encroaching my property, then, for you can't just rush and be like, this is just an application, let me charge 60,000. I'm just doing an application to get the orders. Remember, you have to have a main, like, you're going to file an application and also a plaint. So you have to also factor in. And you remember, now the main suit there's more things involved to it. You'll have to attend mentions, do hearings, you have to do submissions. There's more things attached. So make sure when you're charging your client, get all the facts before putting a figure, because you'll find yourself, you're in a position where you've charged less, and you've charged less money and you're doing more. We normally talk with my friends. We are like, you find you're very busy, but your account is not busy. So ensure you get all the facts, so that at least when you're charging the right amount for the service you're going to render, for the work you're going to do. There's also the issue of self-doubt. self-doubt as young advocates and lack of confidence. That's a very big thing. But when you doubt yourself, remember, I normally say when a client is coming to you, they want you to give them the confidence that you are going to handle this case. They are going, you can handle this case. So, for instance, a client comes to you and tells you that I've been fired unfairly from my work. I don't know what to do. This person wants you to assure them that you're going to handle this case well. But if you're doubting yourself and there's lack of self-confidence, trust me, you'll present that, like, how you will not present yourself in a way that this person is going to feel confident. But they have had clients who come to your office. You are maybe the second or the third advocate they are coming to, because they tell you that I reached out to some few advocates, but I didn't feel that confidence that they could handle this case. So that's why I normally say confidence is everything. Confidence is everything when it comes to being a lawyer. Because even you, for instance, even if it's you, imagine if you're on the other side, you are the client and you're approaching an advocate. You need to have that confidence that this person is going to handle your case to the best of their ability. So just ensure that is something that, anyway, but confidence is something that you build over time, but just make sure. But the best way, I normally say, the best way you can build your confidence, ensure when you're going to meet with these clients, that initial meeting, or maybe that initial phone meeting or Zoom meeting, you are well prepared. And me, the secret I normally use, the tactic I use is first, during when we talk, before now we set up the meeting, I find out what is this client, because clients are different. What is this client actually looking for? What is this? Don't generalize. So just find out what are the issues that they want to be settled. So confidence is everything. Confidence is everything. And the best way you can build your confidence is just ensure we are well researched before going to have that initial meeting. Because remember also, because without that, the reason I'm putting that as a point is because without that, you are not going to get that client. That's why you'll find yourself having a lot. That's also me, I won't lie. When starting out, it's normal. There's that fear, self-doubt, and the clients will not notice it. So that's why you find yourself having meetings, but they don't turn up into briefs. Having initial meetings and they don't turn up into briefs. So ensure that is very important. Confidence. Another serious mistake that we as the young advocates we normally make. We don't charge for consultation in the hope that this person is going to become a client. That's the biggest mistake. So you give free consultations, and in these consultations, because now the people who have been there, they know, because you want this person to be your client, you give 150%, hoping that this person is going to be your client. So remember, you're working, that's your time, and you have bills, so if you can't afford to be giving out free consultations, unless maybe you are maybe doing pro bono, or maybe it's a current client, or a person who has been referred by a current client has referred you, a client who's already paying you retainer or maybe good money. But avoid doing free consultations, please. Because normally when you charge, remember, you don't have to charge a lot of money for the consultation, because most of the time you will find this person, most of these clients, let me tell you, most of these clients, they normally hop from one advocate to another, one advocate to another. So you'll find that this person is just getting advice here, there. They are not intending to find any sort in court. They just want to get advice. Others, even they're gathering information to go and file the suit on their own. That's why you'll find it's common after maybe a consultation, you'll find some clients call back just asking you, like, I had a question, nilikuwa nataka kuuliza kufaili kesi kotini itatukost kangapi generally. This is a person who chances are they're intending, now you have gotten the information they want now to file the suit, so they want to see how much it will cost them. So ensure, charge for that consultation, and you trust me, serious clients will always pay for it. And then there's also this common mistake that we normally make. You charge less at the beginning. The biggest thing here is normally most of us advocates are normally scared, especially when you're starting out. You're normally scared you lose this client. So you're like, this person, like, for instance, even let's say even drafting a sale agreement, you just like, hey, this person, if I say 5,000, if I say I'll charge 50, depending on the value of the property, you can imagine maybe the value of the property is supposed to be around 50. Maybe you're supposed to charge, legally, you're supposed, even according to the remuneration order, you're supposed to charge, let's say, 50,000. But in your head, you just like 50,000, this client might run away. So maybe you tell them I'll charge 10. Then you're charging, now, basically here, you're charging with the hope that you'll increase the fees later. That's the biggest mistake you can make. Trust me, that's even like this client is not going to feel like you're trying to extort money from them. Because that's why at the big as I've said at the beginning, begin from the beginning. Just from the beginning, lay everything on the table. I know the best, I've always give a breakdown. Give your clients a breakdown. A fee not breakdown. That really helps. Because for instance, if you're charging for, let's say, even the suit I was talking about, where you have to first do an application, then a main suit. If you tell the client I'm charging 300,000 for this, they'll feel like you're overcharging them. But if you break it down, I'm just giving an example, but if you break it down to them, you tell them filing the application, submission, mentions and hearings for the application, submissions to the application, and then now you put in the extracting the orders. You just break it down, and then you go now hearing of the main suit, drafting of the pleadings for the main suit, mentions and hearings for the main suit. When you break it down that way, when you break them down that way, it becomes easy, and the client understands. Now they get the point why it adds up to that amount. And then now maybe you can go further. You just tell them, you give them an option, tell them you can either pay the entire amount, or now you pay. Of course, there should be an initial deposit that you can't compromise on, because as I've said, never do work before getting the deposit. So get an initial deposit, and then now later you can tell them now they can pay. You can start by telling them they can pay now the fees for the application. You work on the application first, then later they start paying now the one for the main suit. Like, the point here is, give them a breakdown so that you don't lose a client who's assuming you're just charging them a lot. The moment you break it down, I've realized that it really works, even especially for me when I'm handling conveyancing matters. Sometimes a client comes, they want to purchase an apartment. Of course, you charge according to the value of the apartment. So the moment you just tell them your fees, if you just tell them your fees, because apartments, it can be high, the fees can be high. So the moment you tell them, if you just tell them the fee without telling them what it entails, they normally feel as though you're overcharging them. But the moment you break it down to them, you tell them the first thing you're going to do is ensure they have gotten all their approvals, NCA approvals, all the approvals that is needed under the law. You'll also make sure that they understand what they're getting themselves into, because most of these apartments, you have to join a corporation. They normally have recreation, or like a lot of things are involved. The moment you break it to them that way, they'll understand why they are paying that much. So that's another thing. Break down your fees. Explain. Let the client know what they are paying for. Even you, when you're looking for any service, let's say when you're going to a dentist, and maybe the dentist tells you, like, maybe putting in, like, let's say braces, putting in braces. I normally see it's a lot of money. It's around, even can get to 200,000. It's 200,000. Of course, you'll find that it's expensive. So but the moment they sit down and they break it down to you, they tell you it has stages. There's the first stage where we just tighten. There's the second stage where we do the clean. You'll now get the point why you are paying that amount. So basically, here, ensure you give a breakdown to your clients. Another big mistake, failing to have your agreements in writing. The way I've said, make sure you have discussed your fees from the beginning. Make sure it's in writing, not orally, it's in writing. Make sure it's in writing. Don't, like, just have that meeting and just, because some clients, it get to a point, things happen. For instance, now you have told that person you're going to charge 300,000 for this application, then the main suit, or maybe 200,000, depending on what is involved. I'm just giving an example. And then maybe the first thing you do, of course, court can go left or right. So for you, you don't maybe get your orders first. Maybe court says first, the orders are not going to be granted. You first hear the main suit. Some clients take that as you didn't do your work. So you find some feeling like they start now saying you extorted money from them. So that's why it's very important to have agreements. Have written agreements that you have agreed that this person is going to pay this amount for this service. It's very important. So that in case anything comes up and they start maybe going to LSK to report you, saying that you have evidence. Make sure, please, or sometimes a client may just, there are people out there who was just, I don't even, like, they're just crazy. Because you find someone I've had a colleague who said a client came, not since you have charged them, because remember you're giving them a fee note. The fee note states, let's say 150,000. And then they've only paid, even they've already paid, let's say, out of the 150, they've paid, let's say, 30K, which was the initial deposit. Some clients, go ahead to say that because you've given them the fee note, but you don't have any, then they pay you, then they'll start claiming that they paid you the entire amount and you've not done anything. So that's why it's important. And after every payment, make sure you have paper trail. If me, the important, what I normally do after we have had that initial meeting, and we have already made that, like, you're giving me that brief, I normally prefer I give you my email, you give me instruction to represent you. Then that is where I even send my fee note. After the instruction, I'll now send, we use that as now our communication. We send, and then when you send the first deposit, I acknowledge and I send you even send you, I make sure I even do it. There's a trail in the emails. Of course, I'll still give you the hard copy. So it will really help you. Make sure for every case you're handling, you have protected yourself. These agreements are very important because you don't want also to start being known as that advocate, and actually you're not advocate, maybe who eats clients' money and you don't. Thank you so much for watching. I hope this video has been educative. I'm doing a series on charging clients. So the next video, I'm going to talk about charging criminal clients. Don't forget, please subscribe and like this video. And if you have any question, just put it on the comment section. I'll get back to you.